So this is the second screenshot video. We're going through some typical steps in a personal injury case based on a vehicular accident, and we're down to this last category, which would be connected to what could happen at a trial, or what will happen at a trial if the plaintiff prevails. And quite frankly, it's a prediction of what could happen at trial if the plaintiff prevails, measured by the amount of insurance that's available, that's going to drive considerations of settling the case. I think before I say a little bit more about possible damages, I should just note that most people don't have assets that we could go after to satisfy, if you will, if we receive a judgment against them in a negligence case based on a vehicular accident beyond what the policy limits of their insurance is. And I might add, parenthetically, if we were to jam somebody up in that regard, they could conceivably dump a good part of the judgment in bankruptcy court. What I'm driving at, if it's a situation where there's not an unlimited amount in the context of the case of insurance, and if there's a commercial liability policy, it's not an unlimited amount, but typically we have a lot of headroom. But if not, we just have to pay close attention to what's practical, and I'm going to say that practically speaking, it's going to be very difficult to get money from someone other than the policy limits. So with that aside, or that observation made, better said, let's just talk about possible damages. And we sort of have three different categories that I'm identifying. And the first two are capable of being counted. I know I could say that. If it gets to future lost wages or future medical expenses, we're going to have to bring in an expert who's going to look at what would be reasonably expected in the context of a person's work life in terms of wages that will be lost. And also someone's going to have to take a look, again, another expert, at what the medical experts have been saying about prognosis to see if we're going to have future medical expenses. And there are experts who do this, and they often sort of wrap up what they're doing in a report known as a life care plan. And the right expert, I know the one that we've used a lot, will do a vocational rehab kind of look at future lost wages, and also will be able to put a expert opinion based on the medical diagnosis for future medical expenses. Then we go to another expert who's a forensic economist, and they take the data that the life care person gives us and put it into present dollars. It's just a beautiful thing. So we have those things as items of damages. Now, there may be no future lost wages. There may be no future medical expenses, but certainly that's something that we're looking at from a plaintiff's perspective. The third category, which is compensated by an award of money, involves criteria that cannot be put in a quantitative form, and that's the category of pain and suffering. And you'll notice I have physical and mental. I've always appreciated the distinction between pain and suffering because all of us know what pain is. I was with my granddaughter yesterday. One of my grandkids is a 2-year-old, and she fell and banged her head, and she started screaming in pain. That's the pain that we get acquainted with very, very early on in our life. But we then have this separate category, which is suffering. And what does that mean? It's certainly not the pain of our back or the pain of the broken leg or whatever that may be. But it's suffering looking at what loss of enjoyment has a person experienced and will they experience based on the injuries sustained in an accident. And what I would ask you to do is imagine, because these are kinds of questions that if we felt that there was a recovery or an amount of money to go after, well, we're going to make it worth our time, meaning your time, injured client, and the lawyer's time. I would ask you, what do you love to do, or what are 3 or 4 things you love to do? And it's been a while since you've been injured, so how is the injury impacted on those? And those things could be going running. They could be, one guy I knew had a boat, and he'd love to go out on his boat. It was kind of a bigger boat, and he would take his family out, he would take his buddies out, and they'd go fishing, and sometimes he would go there and hide out on the boat. I almost bought a boat at that point, and he couldn't handle the boat anymore. And I could tell he was like one of these what do you call it, a real Spartan kind of person, wouldn't show pain, and he got to talking about his boat, and I noticed there was tears in his eyes. I mean, that was a loss. So you can figure out those kinds of things and present evidence about it, and the jury is going to put a price tag on pain and suffering. And again, it's this uncertainty in this category that I think, to continue a phrase I've been using, drives a lot of settlements. Of course, when the plaintiff is putting out images of evidence and then arguments of possible damages, the discovery that the defendant's attorney has obtained in the case will be able to permit them to make counter arguments if they're available, including in the category of pain and suffering. And by way of example, the guy who I told you about the boat, he was one of these persons who, and I really respected it, did not want his injury. He had a severe back injury, and he needed to walk with a cane, truly did, and couldn't really work much anymore. And I was so afraid that he was the kind of guy that even though those were the injuries, he was going to go out and start the snowblower, or he was going to get a ladder and take the leaves out of the gutter, or he was going to try to do those things. And my concern was he was going to do those things, and there was going to be a surveillance video taken of him doing those things. And of course, that puts a kick in the pants of the pain and suffering evidence. And so if we think about it, one of the things we're going to tell our client is to be very wary of the fact that you might be under a surveillance video. And that's not to mean that we're ever telling anybody to fake their injuries or to use a limp that isn't there. But what we are telling them is you're going to constantly, or not constantly, but you should expect to be surveilled at some point. And for this guy, at least, what I told him is don't do the things that you shouldn't be doing, because he shouldn't have been on a ladder. And he shouldn't have been out snow blowing. But my worry was that he was, and if he was, it's going to be on surveillance video. I think you get the point. Okay, that gives us a sense then of possible damages. I hope that one of the things that might be coming across is that when we're involved in this kind of litigation, there's really an awful lot of opportunity to be creative. I always think that each case is a kind of a new story and just a very interesting kind of thing to be doing. Okay, I'll stop the video now.